All right, good afternoon, everybody. This is the Leverett Subcommittee of Judiciary Non-Civil. I'm Rob Leverett, and I'll be presiding today. We are not meeting at 3, as I previously thought. We are meeting at 4, so I thank everybody for getting here at the right time, unlike me. So we've got a number of bills to go through. We don't quite have a lot of people here, but we technically, as a subcommittee, don't have a quorum, so since y'all are all waiting, I'm going to go ahead and get started. And I would ask Chair Lady Silcox to open us up with prayer.
Please bow with me. Dear Lord, thank you so much for today. Thank you for the opportunity to serve the people of Georgia. Give us wisdom to make wise decisions that would be pleasing in your sight. In Jesus' name, amen.
Amen. Thank you, Chair Lady. All right. So we've got a sign-up sheet here, which we've taken possession of, and we'll go ahead and just kind of start moving through the agenda in the order the bills appear on the agenda. So, Representative Buckner, House Bill 285. You want to come on up?
Sorry, I won't say that time.
There you are. Do both of our mics work okay? Do both of the mics work well?
They should, yeah.
Okay. Do you prefer that one? Let me.
Well, it doesn't matter. You tell me where you want me to go and I'll talk.
Right there is good. So
Thank you.
The floor is yours. This is House Bill 285.
Okay. Thank you, ladies and gentlemen of the committee and Mr. Chairman. This is a bill that has been around a minute. It started with a real true story of a situation that happened in one of the counties that I represent. There was a person that went into a gun store to purchase a gun, and the storekeeper happened to know the person and know that they had been hospitalized after a dozen 1013s had been involuntarily committed to the mental health hospital, and said, we'll have to do the background check and then we'll come back in 3 days and we'll tell you what's going on. So they did the background check and she was not on the list. The woman that was trying to purchase the gun had numerous situations where she had threatened and tried to harm some people, and that thus was why she was had been committed. So the storekeeper contacted the sheriff, and being a small community, not in Atlanta, a Macon, or Columbus, everybody knows everybody and knows a lot about everybody, and they knew the situation. And so the sheriff was able to go and talk to the family and found out that it had been 5 years since she had gotten out of the hospital, and that she had taken herself off her medicines and had not been acting quite like she had when she was being treated. And they were able to fix the situation where she did not end up purchasing a gun and hurting the person she had in mind that she wanted to hurt. But the local county commission and police and sheriff's department came to me, and so this all happened in 2017, and the first bill was 2018. I've had 4 bills like this. It has gotten out of committee and was on the House floor and went to the Senate the 1 year. It has gotten out of committee and was on the House floor, and we ran out of time in the Senate that time, and then we've had hearings and it hasn't gotten out of committee for a couple of times. But basically all this is doing is that it is saying that every other forfeited right that a citizen has, there is a process to regain that right back. This one, what happens is 5 years after you have been released from the hospital, a computer purges the list, and people that have been involuntarily committed are purged from the criminal background checklist and can purchase guns again. What we want to do is have the person go back to the place and the person that committed them, and do an assessment and determine whether or not they need to stay on the list or not. It is not a red flag law because they've lost their rights, and we're trying to help them establish them if they are healthy enough to have it, based on being able to take care of themselves and not harm themselves or others. The questions that I've gotten in the past, I've got some data for you. Over the past 7 years, there's been 2,066 people that have been involuntarily hospitalized in the state. And of that number, 95.6% have been purged from the list. These numbers come from the Georgia Bureau of Investigation, and they've been very helpful in providing them for me. The other thing that I think is important for you to know is that in the process of this, I did some additional research by hiring a second-year law student to go through all of the school shootings, and this was done before what happened over in Winder, so it doesn't include that one, to see if there were any similarities. And the two similarities for all of the school shootings came down to the shooter had an interface of some type with mental health, to some degree, to different kinds of services rendered, but they had all had an interface of some sort with mental health care providers. And then the other common denominator was that they had all purchased their guns legally. This is I'm a public health educator by profession, and prevention's worth an ounce of prevention is worth a pound of cure. This is not going to be a fix for all the major shootings, but if we do stop one, that's enough. It's just a good prevention measure. I'd be glad to answer any questions at this time.
Well, thank you, Representative. I wanted just to touch on a few broad ones. So currently, as I read the law, just as it appears in your bill, there's sort of, I guess, a presumption that at 5 years the person is ready to have their rights with respect to firearms restored, and so it automatically, there's sort of a 5-year, you're off the list at that point. And your bill would just shift that burden so that the person would stay on the list until they petition and establish their, if you will, healthy and eligible to be able to be issued a gun under the current sort of standards for a weapons carry license. And I think the standard here is that they must show by preponderance of the evidence, which is the normal burden of proof, that the petitioner will not likely act in a manner dangerous to himself or herself, or that endangers public safety, and that granting the relief, which is the restoration of, I guess, the ability to be able to purchase a firearm, is otherwise consistent with the standards for issuance of weapons carry license. So, and it contemplates a proceeding, I think, in probate court, I believe.
And the reason for that is in the counties that I represent where this happened, that's where the action would take place.
Okay. The court in which the hospitalization proceedings occurred would be that same court.
And the significance of 5 years from the health side is that that's about the time people decide that they are either tired of taking the medicine or they think they're cured, and that's from 5 to 7 years is when most of the patients will stop taking medicine and sometimes have a relapse.
And I guess there's a danger once they go off meds of relapsing. And so the petition gets served on the opposing civil party or a prosecuting attorney who appeared in the initial case in which the person was committed. Is that correct? If I'm reading that correct on lines 41 to 43.
I was trying to figure out where you were reading that. So thank you.
Line 41, about the middle, a copy of the petition shall be served upon the opposing civil party or the prosecuting attorney, as the case may be, or their successors who appeared in the underlying case. Underlying case, I think, is the underlying case in which basically they were put on a list that would preclude them from purchasing a firearm. Would you agree with my characterization of that?
Yes, I'm sorry.
Okay.
I was shaking my head and not saying anything.
Okay,
I
I'm sorry.
apologize.
Sorry, I
No,
was
it
not
was my
looking.
fault. I was
And
thinking.
And then the court holds a hearing within 60 days. They can extend that for good cause. The prosecuting attorney can represent the interest, and then the court receives this evidence. And I'm assuming if whoever the adverse party in this proceeding is feels the person it satisfies the standard, they could consent to the restoration of the ability. Doesn't expressly say that, but that would be my assumption, I
That's
guess.
what
Okay.
the intent was.
All right, I believe Floor Leader Hong has a question.
Thank you, Mr. Chairman. Thank you, Representative. So we're talking about an individual who may or may not have committed a crime when they were involuntarily hospitalized, correct?
Correct.
Okay, so they could have just had a family member that would have called and they were hospitalized for that reason, not having committed any crime, whether or not it involved a firearm or not. Is that correct?
It is my understanding that the idea is that if they had demonstrated behavior that would put themselves or others in danger, and it was because when you do the 1013, you are assessed, and it was assessed that they needed to be hospitalized for whatever behavior they had demonstrated, and they were hospitalized. Then at the time that they're hospitalized, they are put on the list to not be able to. That's already out there. So what this would do is when they are released, they can show that they are healthy and well and not going to hurt themselves or others, and they would be eligible to have their name taken off of the criminal background check list and be able to purchase a gun.
Right, I understand that, but
But
that individual may or may not have committed a crime, may or may not have had a weapon on them at the time.
Correct.
Is that correct?
Correct.
Okay, thank you.
Kelly Silcox.
I was just going to comment that I think this is a great improvement over the last bill because unlike the existing law that just says they come off automatically, I do know that most people, if they are subscribed or prescribed psychotropic drugs, they should stay on those drugs for the rest of their lives. And so if they are being compliant and they are taking those drugs regularly, and they can show that through this hearing by the preponderance of the evidence that they can be responsible, then I think that's warranted. But I think it's way better than what we have.
Thank you.
Thank you.
Thank you. Floor Hung, do you have another question?
Just me.
Oh, it's you. I was going to say, Floor Hung, you got a lot uglier.
It's true. That is, I can't deny that for sure. I'm slow today. My brain's tired, so I'm trying to wrap my brain around what we're talking about here. So today, you get committed, involuntarily committed. Today, you're on the list for firearms. For how long are you on the firearms list today?
From the day you were released from the hospital, 5 years.
Okay. And you're trying to do what one more time?
I'm just saying that there should be a process to come off the list rather than it just being a computer purging the list. At 5 years, there are a lot of people that are tired of taking their medicines.
Yeah,
and,
I
and
heard that
all
part. I get that.
So
what
it's a random. Right now, it's random. They just everybody that it leaves the hospital 5 years, they come off the list.
is there a cost associated with meeting the new requirements to come off the list?
It's no different than them bringing them off the list as a batch. This way, they
Is there a
would
cost?
become
Is there? Say I'm involuntarily.
Committed.
To the
Committed.
individual.
Yes.
I thought you meant to the
Not to the state. Right.
agency in the state, because there's not one to that. Well, there would be the cost of time and effort and energy to go back to the probate court and prove that you're healthy enough not to hurt yourself or others.
Would you need a lawyer as part of that process?
I would think that a lot of people would choose to hire one, but I don't know that you'd have to have one.
Okay.
Because it's not like a trial, it's a hearing, but I'm not a lawyer, so y'all would know that answer better than I.
If I could just chime in, my thought
Please.
would be you'd be advised to have one
Right.
just because there is a statutory procedure that's set out in some detail. Just like anything, you don't have to, but that would be, I think, a
Pro
possibility.
se is never. I mean, most of the time, pro se is not really a good
Yeah, the expression
option
is,
for someone to do.
He-
So I want to protect society too, but I also want to protect individuals and their. It's a tough one. I mean, there's no. This is one of the more tougher ones I've had in here, as far as like, for me.
It might make you, this might make a difference, it might not, but we are the only state that does it this way. Every other state requires a process, and every other person that goes to jail, they lose their right to vote, and they have to go through a process to get their voting rights back. They lose their driver's license, and they have to go through a process to get their driver's license back.
Well, driver's
This
license is not a right. That's just a privilege. But
but any forfeited right or privilege that I've been able to research, there's a process to get it back, except for this. And this has some life-changing implications for lots of people.
Well, I'm sorry, did you have another follow-up?
I'm thinking. Sorry.
Okay. Well, I'll ask a question too, so you can keep thinking. As I read the bill, and correct me if I'm wrong, you're shifting from a presumption at the end of 5 years, but allowing someone to petition to have their name, I think we're referring to it as taken off the list, which is kind of what is happening. But you can do that at any time. You can petition after a couple of months. You could petition after a year or 2 years. And presumably you could refile the petitions if you felt like something had changed that would justify, even if you were denied at one point, you could
Correct.
refile. Is that your intention?
It was not my original intention. I wanted them to not be able to do this until the 5 years, but going through it so many times, other people thought that should be more open.
Mhm.
So that this was the last version that passed that people agreed to.
Have you given, just sort of picking up on what I sense is Chairman Gullett's concerns, have you given any thought, well, I expect you have and probably rejected it, but had you given any thought to leaving the presumption in, but allowing the early petition as well? And I think what you are after is you don't feel like there should be a sort of arbitrary presumption.
The
At the end of a period of
arbitrary
time.
purging of the list by the computer is troublesome to me, yes.
All right, thank you. Do we have any other questions? I don't see any. I think since, of course, we don't really quite have a quorum, I think I'm going to make this a hearing only because that's the practical effect of it anyway. But I would like to chat with you a little more about some of these provisions and see if there's anything that we could try to tweak since Chairman Gullett's concerns probably are characteristic of other folks too. So
I'd be
maybe we
glad
can-
to.
That would be
Appreciate
great.
that. I appreciate the hearing.
I appreciate it. Appreciate you coming here
And
and you being on time, unlike me.
thank you all very much. I
Thank
appreciate
you.
it.
All right, let's go on to House Bill 4. Well, we'll wait on 430. Representative Saines is, I think, in another hearing. Huh? Yeah, Chairman Gunner's here. Why don't we go ahead with yours?
I know. I don't care as much.
Join me up here.
All right, Chairman, when you're ready.
All right. Thank you, Mr. Chairman. Appreciate y'all letting us present this bill to you. This is LC 492281S. And I've got a phone a friend here to help me out. I've had very little time to read through this totally, but I think I understand the gist of what's going on here. This is a bill to give a second chance or to help people that have been convicted of a crime in which they were coerced to commit. And this is more
And if
about-
I can interrupt you, we're dealing with a proposed substitute here, correct?
Yes, sir, that's correct.
492281S.
Right, there were some changes made to the original bill, and there's going to be one more made to this when I get to it. Everybody good? Okay. So basically, just and generally speaking here, someone that's been coerced to commit a crime, and we're talking about serious offenses, this gives them a chance to present that evidence to the court. And this is not a get-out-of-jail-free card. This is a reduction of sentence if the court so chooses to do so. And it's in the court's discretion based on the evidence presented to the court what it's done. The court can deny the relief that they're asking for, but the court needs, in the order, states the reasons for that. So, but that's basically the bill, unless you want to say something that I've left out.
No, I think that's pretty much it. We're really focused on survivors of domestic violence, largely whose convictions are substantially related to the abuse. So as Chairman Gunter noted, kind of looking holistically at, we know this is a substantial problem. Between 74 and 95% of incarcerated women report abuse in their lifetime, whether it's domestic or sexual violence. My name's Ellie Williams. I'm the legal director of the Justice for Incarcerated Survivors program at the Georgia Coalition Against Domestic Violence. So I'm a criminal defense attorney. I largely practice in the post-conviction space and represent these specific people. So we know that there are a lot of these folks, and as Chairman Gunter explained kind of on the front end, the system is constructed in a way that the evidence of abuse can't be meaningfully considered. Even if it can come in under the rules of evidence, the standards in specifically self-defense and coercion, as Chairman Gunter pointed out, are such that it really can't effectively be meaningfully considered, which I'm happy to go into more detail about that. So survivors end up convicted. They end up after that with harsh sentences, which we're proposing a standard that if they can show that they were a victim of domestic family violence, specifically dating violence or child abuse, and that was a significant contributing factor to the offense, the judge would then reduce or sentence them under a reduced sentencing scheme. And as Chairman Gunter noted, too, providing a vehicle for folks who have already been convicted to have a chance to come back and ask the court to take a look again, knowing that a lot of people in our state have been in prison for a really long time, and our understanding of domestic violence has evolved so greatly. We've seen the code catch up in other areas, but this is one where we're still lacking, so making sure they have a chance to come back and do this. And similar bills, specifically with the resentencing, it's becoming popular around the country. Oklahoma passed one last year. North Carolina is working on it right now, and a lot of other states. It's certainly recognized as a challenge and a good solution to it.
If you're worried about the number of cases this may open up, in my 12 years as a DA and 7 as a judge, I rarely saw this type of case out there. So, or maybe it just wasn't ever presented to me, but I think it's pretty rare.
Could I ask, in your experience as a judge and as a DA, are you concerned that putting this in code would encourage a greater proliferation?
It will encourage some, but again, I don't think the numbers are enough there to overwhelm. And I think there's evidence from other jurisdictions that they've not been overwhelmed by.
Oklahoma's implementation has been successful so far. It's going well with their prosecutors. We are in regular contact with their folks. The first petition, the woman actually succeeded, left the courtroom a free woman. The DA's office isn't appealing. And in New York was one of the first states to do it. It's been on the books for almost 6 years. They've seen just around 200 petitions and resentenced right around 80 people. And one thing that to point out in our case, the way it's structured would be that it would, of course, go back to the trial court, so it wouldn't be like a flood for one particular office. They'd be distributed around the state. So we anticipate not any substantial flooding the court's challenges.
So does the statute, and I apologize, I hadn't had a chance to look at it, but would it allow you to make the argument at trial or at sentencing, or does it allow you to come back and ask for a modification based on that?
Both, I believe.
Both.
Mm-hmm.
Are there any limits on the ability to seek the modification?
So
Is there a time limit or anything of that nature?
No time limit. What we did try to do, and we wanted to make sure a couple of things. So we wanted to make sure that everybody had a meaningful opportunity and give as many people who we know are in this situation the potential to succeed if it's relevant, or if they can succeed under the standard. In order to guard against flooding the courts, what we tried to do was build in a kind of minimal evidentiary standard that the petitioner must meet in order to be granted a hearing, so that the court doesn't get hearings on frivolous petitions. We also did build in a way, though, we know that the evidence in these cases is challenging by abuse's very nature, even in current cases, but particularly when looking at older cases based on documentation procedures, but also how abuse was handled 30 years ago. So we also did build in an option for if they don't quite meet that standard, but the DA's office agrees that they think it should move forward, then they can get back into court.
And I'm going to ask just one more question, then shut up, because there are a lot of folks who have a lot more expertise on criminal practice than I do. But it looked like you're changing the justification statute, which doesn't justification usually go to guilt or innocence, or does it go to sentence also?
It goes to sentence also.
It can go to
Yes.
anything. Okay, all right. So, and I think your testimony was this: you are limiting though the scope of the remedy here so that it would apply only to sentencing.
Yeah, I believe that would be.
We would
correct,
be,
yes.
the particular piece of what we were just talking about, did the abuse occur, is it related to the offense, would be specific to sentencing. We're additionally proposing reform to 2 justification defenses that do also get at guilt or innocence. But the thought there was that we want to make sure when we're looking at this issue that we're addressing it holistically and meaningfully. And if we're going to propose resentencing people, hopefully from an efficiency standpoint, if we're doing a better job of accounting for these dynamics up front, then we would avoid a lot of people coming back and asking for resentencing if the abuse was effectively accounted for up front, and prevent these improper or convictions that don't account for those dynamics.
Okay, thank you. Shirley's okay.
Thank you, Mr. Chairman. Well, no, thank you. No problem. I just wanted to thank you for bringing this. I will say that having worked in the sex trafficking area a lot, there are a lot of parallels because a lot of violent behavior is normalized in these situations where there's extremely violent behavior going on in a home to either a wife or children or both. And so to the degree that that is normalized, and it's an ongoing situation, I like what Chairman Gunner said, that it doesn't give you a get out of jail free card, but it gives people a chance to come back and say, you know, this was normal behavior in my house, and I know that it was wrong, but unfortunately, you know, part of this was out of self-defense perhaps, and part of it was survival.
Certainly.
So thank you.
Thank you very much.
Okay, now with the chairman sitting down, have we gone from subcommittee to full committee?
I'm just reliving the most fun I ever had in the State House, chairing the subcommittee.
We do have one change in the bill on line 22, where it says the defendant, the shall be permitted to is struck and replaced with the word may.
What made you change your mind on that?
They told me. And it seems, in reading it, it seems a better way to word it, in my mind.
And we had some conversations with the prosecuting attorney's council, and we all kind of came to a collective decision that this felt like a better route that we all agreed upon.
Well, if they don't allow it to be offered, y'all keep up with that and let us know. We'll go back and put a shall in there.
Yeah. Okay.
Any other questions from members of the committee? All right. We have anybody signed up? We got several signed up.
Okay.
Thank you, Judge.
I'll get out of the way. Thank you.
Thank you.
All right. Let's see. Robert Smith with PAC. I'm so glad you get to testify today. We've robbed a treat too many times.
I'm sorry, Your Honor. I had to go be a real lawyer yesterday, I was in court, so I apologize for that.
Good to see you.
Hi. The reason from shall to may is the question is about when you say evidence shall be admitted, that means the court doesn't have discretion over whether or not it goes through the appropriate balancing test to see if it's probative, prejudicial, and if it's relevant. That's why we asked for the shall to the may. This bill is there's still some things that we're working through with our partners at the Georgia Justice Project to kind of get this bill, I think, to a place where everybody's happy and everybody's comfortable with it. There is a very compelling argument about how our understanding and notions of survivors and what this legislative body has looked at with the human trafficking. And there are some things that existed years ago that we didn't appreciate. So giving us this opportunity to look back would be helpful. We also want to make sure that we do protect our victims at all costs, that we are focused towards victims. The ones that need the restorative justice, we protect them. The ones that need protection because they are victims as well, we want to make sure we can stand up for them. So we're continuing to work with the sponsor, continue to work with the advocates, and that's what I've got to say.
Very fair assessment. Thank you. Any questions from members of the committee? All right. I see none. Good job, Rob. All right. Donna McMillan. Donna McMillan. Oh, there you are. I'm sorry. Afternoon.
Afternoon.
Go ahead whenever you're ready.
Okay. Well, I probably carry the most weight as far as personal exposure to this kind of issue, and hopefully a fix that will be giving hope and just a future to so many, because we've talked about the things that are affecting our state, and we have to realize every time we turn on the news that domestic violence is affecting our state, and it has come home to my house and my family. Well, first of all, let me tell you a little bit about our girl. She was, as a child, just very rambunctious, grew up in a rural community that always allowed for getting out and running the fields and the pastures of her grandparents, and enjoyed being a child. But it was a protected environment, and I grew up in that same environment. And so much of legislation and what we have to face today, whether it be ignorance or lack of knowledge, I didn't teach my kids about domestic violence. I never lived it. I didn't know what it was. And then as she grew up, and she was very determined. In fact, we used to comment that she came into the world thinking she could change the world and everybody in it. That can be good, but it can be bad if you meet the wrong person, and she met the wrong person. Initially, it was a boyfriend, a high school sweetheart, that was quite accomplished athletically and achieved academically, and it was an attraction for her. And they dated for several years. She got some college education behind her, and they ended up getting married. But the doors of domestic violence did not close. It opened even wider. So she lived in that for several years, and finally shared with us that it was not great, which there are no perfect marriages. So she said, but you told us that marriage was for life. Well, marriage is for life as long as it's a good marriage and both parties are working and both parties are respecting. That was not the case. So in a much effort and much mental strain and just efforts of trying to figure out whether she was doing the right thing or not, she finally got out of that with a divorce, but in the meantime there was violence. And as she said, I closed that door behind me, I boxed it up, and I thought I would know everything there was to know about violence if it ever knocked on my door or even came close to me again. And 3 years later, she met a young man that was 9 years older than her, was quite accomplished, had an avionics engineering degree through the Air Force, And she had worked really hard and was working for Gwinnett County School System as a retirement counselor. Things seemed to be going well. He had a home that he was leasing in Woodstock, and she would drive from Woodstock to Gwinnett County, Swanee, for her job. And this went on for a while, but prior to her marriage to him, she had purchased 6 acres out near us in Monroe. So he had a chance to buy an avionics business in Gwinnett Airport, so they decided to build their home on that 6 acres that she had purchased. And he had already been married before, she had been married before. It seemed like they had put all of the disasters behind them as far as that could possibly be related to domestic violence. But as she said, immediately following the wedding ceremony, she saw another side of him that she hadn't seen. He was frustrated with his family that arrived late for the ceremony and didn't give enough time to him as he was getting ready for the marriage vows. So it went downhill from there. She soon found out that she was pregnant with a little boy that we call Mason, and he's very well achieved now. He's 18 years old. We started having full custody of him at 5. But while she was pregnant, just a few incidents that she never reported all of them, which is the sad part about it. He jerked the shower door off the hinges and threw it at her when she was pregnant, and just horrible things. It's even hard right now for me to sit here as a mother to tell you that. But anyway, they continued with the marriage. It progressed on to the point that in the last year or so, she felt like he was drugging her. She would go to bed at night, wake up the next morning in another part of the house, maybe even a closet, with not the same clothes that she had had on the night before. So on one of those particular occasions, she was able to go to the hospital. And she told the hospital authorities, "I think my husband is drugging me." And they did no drug panel to see if she had drugs in her system. They just did a normal drug panel. They did in their report say that she had voiced concern about what she was experiencing at home when the violence, and that's in the report. So at that point, she was starting to believe that nobody cares that I'm being abused. If I've reported to authorities and it got me nowhere, then why am I even bothering? Later on, as things are progressing and the violence is getting harder, and she's already applied for a divorce, I was with her the next day after she reported or called the divorce attorney to set up an appointment. Her husband called and said, "You're not getting a divorce, I'm not ready for it." And it seemed at every point there was some kind of tracking, that he knew every move that she was making. So things were getting pretty bad once he figured out she was wanting to get the divorce, and they had already started sleeping in separate bedrooms. And on the morning of December the 28th, there was a break-in at her house, and a cop came to investigate the break-in, and she was able to tell him, "I'm more afraid of what's in this house than what's outside. And can you please give me a temporary protective order?" And he said, and this is a quote in transcripts, "I would have to come in this house, find him on top of you, beating you to death, before I could get you a restraining order." So once again, why am I bothering? Nobody cares. If law enforcement doesn't care, hospital didn't care, at no point was there ever a pamphlet for shelters or any kind of contact information where she could possibly get help. She had tried to get a rental house to just get out of his way, let him, if it was a temporary mental kind of status that he had encountered, maybe she just took the baby and went into a rental house, and he wouldn't let her do that either. She was packed several times to leave, and each time he would find out and stop her. So at the end of the day, she had to decide life or death, because he came into the room in the morning of January the 2nd and assaulted her and told her if she tried to leave that he would kill her. They live out in that country setting, rural setting, and the alarm was on to the house. Had she tried to raise a window or open a door, he was going to know. But he said, I will be in to do more harm before the night's over. So about 3 o'clock in the morning, he came in, and she saw something shiny in his hand and a bottle of medication, and she chose self-defense at that point. That's hard. It's still hard. But at trial, so much of this was not understand. Why didn't you just leave? Was one of the questions. Well, leaving is not an event. It's a process. And the process had not worked well for her. So she was convicted of murder, sentenced to 30 years in prison, which she has served 17 already. We have custody of the son. We've been through all of the appeal options that we have, and everyone has failed us. So I'm really hopeful, and have for many years looked to lawmakers to create some kind of legislation like this that gives, on the front end and after the incarceration, an opportunity to say this was not what should have happened. And she was in fact being drugged. Let me tell you, we had hair samples taken after the event by our inspector. They found ketamine, they found a date rape drug, they found hydrocodone. So he was drugging her. But in any case, we're not alone in this. We have met so many families, and families that are not as blessed as I am to have a voice, and God's given me a voice, and I hope it's received well by this panel. But I speak not only for my daughter, but so many others, and for the families that the daughters are gone, that didn't have a chance to make it right. So I appreciate your time, and I hope that we can get something done here. Thank you.
Thank you. I see no questions from members of the committee. Thank you
Pardon
for
me?
coming here. Thank you for coming here today.
All right.
There's no questions.
I wouldn't have been anywhere else.
Thank you for
Thank you.
sharing this with us. I know
Thank
that's
you.
tough, but looks like you do have a question now. Representative Holly.
Thank you, Mr. Chairman. I just wanted, I know sometimes it may be hard coming before a big group of people and happen to rehash some good, but also some very painful experiences. Mm-hmm. And while sometimes we differ in opinions here, I appreciate you trying to at least do your part to honor those who are in your life, who have been able to suffer and still withstand, and that it's good for you to just honor justice by being here. So thank you for your vulnerability and helping to inform us.
Thank you.
Thank you. Thank you. Appreciate it. All right. Let's see. Next, I have Ellie Williams. Oh, gotcha. Sorry, Ellie. I apologize, Ellie. All right. Next, I have Wade Askew. He waves.
Nothing to add.
Good.
We're committed to keep working with partners to get this done.
Okay. I believe that's all I had on this. Any discussion or you want to have final say, Judge?
I'm fine.
I want to thank the judge for doing this. I know we'd talked for a few weeks about this one, and I commend you for bringing this. Any other discussion from members of the committee?
time.
All right, this is the time.
Mr. Chairman, I put forth the motion of this measure to pass.
All right.
Second.
Motion second. Do pass. All those in favor of, excuse me, there is one amendment needed. All right. I believe it's in line 22. Somebody want to make that amendment? All right.
Shall to May.
All right. Well, I'm going to turn your mic on so we got the record. Go ahead.
Yeah, I move that we change that shall to May, line 22.
Did they want it to be permitted to as well?
Yes.
Yeah. Just strike the shall be permitted to and then just say may.
So I understand your amendments to change the shall be permitted to a may in line 22, correct?
That's correct. Yep.
All right. Y'all hear the Golden Amendment? Do I hear a second? All right. Move second. All those in favor of the Golden Amendment say aye.
Aye.
All those opposed, same sign. All right, it's on. Any other amendments? Seeing none. We got a motion second. All those in favor of the bill with the Golden Amendment say aye.
Aye.
All those opposed, same sign. Congratulations. Thank you, Judge.
Where does this go back to the full committee?
I'll hear you first thing in the morning.
Okay.
8 o'clock.
8 o'clock?
8 o'clock.
I'll be here. Thank you.
I'll try my best to get here by 8 o'clock. I don't know who it was scheduled that. Have we heard Jordan's? All right. I tell you what, let's go with House Bill 195 next. I got some folks here that's on the clock in uniform. Representative Ridley. And the reason I'm attenuated that, I got chewed out one time for subpoenaing about 5 officers on duty and had them sit there until about 2 o'clock in the afternoon until I could get there from a court of higher jurisdiction. So I understand y'all's time is valuable, so thank y'all. Go ahead, Representative Ridley. House Bill
195,
195.
LC 442910. This bill, it's only 2 pages. It's just a few lines, and all it's doing is saying that the Department of Natural Resources has to have probable cause to board your boat when they stop you. You know, road cops don't just pull you over and search your vehicle, so all we're doing is trying to provide parity. And I know there's some people here from the department who are going to say it's the end of the world, but it's not the end of the world for the road cops that do it, so we're just trying to protect people's Fourth Amendment rights and, you know, bring parity that you see with other forms of law enforcement.
Okay. That's the shortest presentation I think I've seen in here in a while.
I don't know how many bills you have in here that are only 32 lines.
All right. Okay, any questions from members of the committee for Representative Ridley? Y'all a quiet bunch. Okay. All right, thank you.
All
We got several people signed up for this one. Let's see. Is that Thomas Barnard? Bernard. Okay, now I got you. Thomas Bernard. Afternoon.
Thank you, Mr.
Yes,
Chairman.
sir.
Yep, north of I-16 it's Bernard, and south of that it's Barnard. So I learned that throughout my career. But first, Commissioner Walter Rabin sends his regrets for not being here. He's at the hospital with his mom, where he should be, as she's having some tests ran on her today. But we do have some concerns with this. I want to list those out for you real quick. Again, I'm Thomas Bernard. I'm Deputy Commissioner. I've spent, as a white hair shows you, 32 years in the department, and 5 of those as a colonel, a law enforcement division director. I was also over our critical incident reconstruction team that handles all the boat crashes and different things. But based on this and looking at this piece of legislation, it will severely limit the ability of our game wardens to keep the waterway safe. And when you think about that, there's only, these guys right here, there's only 200 of them statewide. When you think about that, that's 16,000 miles of rivers, a lot of rivers. 500,000 acres of impoundments, and that's like a Lake Lanier, as we're all familiar here. And then 100 linear miles of shoreline on our coast, and we go out 200 miles offshore. So that's a full day if you're doing the 200-mile trip there. But the proposed change on the burden of proof here with the probable cause piece. When you hear that, that's a lot higher than it is on the road. On the road, it's reasonable suspicion when we stop someone on the road. Currently, we have a policy in place with our folks that we require reasonable suspicion before they stop a vessel. We just don't arbitrarily stop folks. It's important to us because we have so very few of our folks on the waterways that we're working those complaints that we may have from citizens and dealing with those suspected drunk boaters that could be on the waterways. Also, when you look at the Boating Safety Act, there's a lot of requirements that people have to have on board those boats when they're out there. Another piece is, as you well know, when you're on the highway, you've got yellow lines and you've got white lines, and when you're on that water, there are no yellow lines and white lines. So it's very important for us to have this ability to enforce this law. When we look at Peruzzi versus State, this was 2002, this was a Georgia Supreme Court with all justices confirming on that constitutionality of OCGA 52725, and that's what we're looking at today. That case was challenged, but they all affirmed that it was constitutional, and that when we do stop a boat, that it's a minimal intrusion. And as they also state within this case law, that unlike cars traveling on public roads, vessels on open bodies of water originate from large number of docks and launches and need not follow any path or lane, so they don't have the roadways that we have in our vehicles. And in this environment, we can't really do roadblocks either, right? We're not capable of doing that. We talk about Terry v. Ohio, just as a police officer. When you look at that, you've got the different types of stops that you make with an individual. One is voluntary, where you're having that conversation and the person's free to leave. And then we get into an investigative piece where you may think something's going on, you're not really sure, and that's where that reasonable suspicion, about 20%, you think something's not quite right. You know, if you're driving past a house and it's 2 o'clock in the morning, you see someone looking in a window, well, that may be the homeowner that can't sleep that's out there working, or it could be somebody that's about to break into that house, so you've got to go see what's going on, right? That's that reasonable suspicion something's not quite right. And then it moves on into what's called probable cause. Probable cause is at the point where we actually affect the arrest. And so for us, if you look at boaters, under the age of 12 can't operate a PWC. As you know, they travel at a high rate of speed. So when you're on the body of water and you're looking at people, you see a young person, you don't know whether they're 10 or 14, you don't know those things. And so if we had to have probable cause, we would have to have that knowledge before we stop that boat. Hit and run on the lake. If we have that, and let's just say the call comes out and it's a white boat, is the call that we get, unless we know the white boat that struck the other boat that caused the fatality is that boat, we can't stop that boat if it's probable cause only. Reasonable suspicion allows you to grab the white boats as they come through to check for a brief, have they made that contact, do you see that? Cut them loose and keep grabbing folks as fast as you can. So that's the difference there on reasonable suspicion and probable cause. And then you think about the marine toilet piece. We inspect those regularly, especially on Lake Lanier and those larger impoundments, and that's our drinking water. And if you've ever been on a dock, let's just call it an A dock up there, they'll run from A to Z and there'll be hundreds of them. There's no way for you to know if you see sewage coming out which boat that is. And so you would have to have probable cause to find out who's actually dumping in the lake and not use an actual pump out facility. So we've gone to the far end of that. The last piece I have there is, again, reasonable suspicion is what we ask of our officers today when they stop a boat. And in a lot of your cases, you have to have that to get to probable cause in order to make an arrest or write a citation.
Okay, thank you. And our prayers go out to Commissioner Raven's mother, too. One question, just interesting thought process. I've handled a couple of cases dealing with craft on water, but wouldn't say that I feel expert in this matter. We have certain roadblocks that are set up on dry land on our roads, obviously. Is there any equivalent for DNR on our waterways of doing that same kind of thing?
Yeah, we don't do that. Just the sheer number of, one, it's hard to find a pinch point on a body of water. So that makes it almost impossible to do that. And then you look at our coast down there, those waterways are so broad that it's really not possible. So we don't have those pinch points like you do on a roadway.
Okay. Well, number 7, Representative Holly.
Thank you, Mr. Chairman. Thank you for speaking on this. You know, you're right. I guess when I'm looking at so many times, if you're on a set street that already has these guardrails, there's so many ways within which you can have a stop, and you can be able to see. But on a waterway, everything's so fluid. To me, this makes sense, but kind of the question I'm wondering as well is, there's unlike, like, for instance, if there's a car and once you're past kind of that probable cause phase, if, for instance, you believe that there's something illegal that's inside of the car, you have to go and apply for like a search warrant.
Correct.
How is does this in any way, because you're now having to board a vessel, and then does that in some way conflict or there's a challenge, or the kind of that Fourth Amendment right, for
search and
seizures,
yes,
and unreasonable search and seizures.
Right. So I'm trying to understand the question. So if we board the vessel or board the boat itself,
right,
each person is required to have a life jacket that fits that person from infant to adult. They have to have the proper size. Sometimes those are in compartments that are not readily available or accessible, as we call it. So they will have to get those things out. If you were to suspect, I'm just trying to draw a parallel. Let's just say we pick up on the fact that there could be narcotics in the boat, like you would a car.
Right.
At that point, if you've got to start searching compartments and things, then we would get a search warrant for that.
Gotcha.
Yes.
Okay, that makes sense. Yeah.
All right. Number 11, floor lay on.
Thank you, Chairman. So, and I'm kind of looking at this code section, so I just want to be clear. And there are other enforcement powers here: arrest, execute warrants, serve subpoenas. This section is just touching on inspection, safety, equipment, and it's not touching on the other sections that I just mentioned with exercising other powers of the officer. Is that your understanding?
Yes, ma'am.
Okay.
So we've got, this is what's called the boating code. So that's the 52, and then we also have the 27 code. So fishermen and hunters will use boats as conveyance as well. It's a little bit different when you look at that. So we also, not only are we working the boating enforcement piece and making sure that they have the fire extinguishers and those things, if they're fishing, that the creel limits are they're not over the creel limit. If they're hunting, they're not over the bag limit and those sorts of things. So then it kind of parallels each other. The same officers doing the same function as well, if that's what you're asking.
It is, and I don't do boating law, but criminal law in that sense.
We
But
can change that.
So yeah, so however, if an officer boards a vessel for, let's say, to examine a document and safety equipment and sees some kind of criminal act, then they will have the right to investigate and arrest at that point.
That's correct. That's
and
correct.
not separately, they've already boarded it based on not consent, but based on essentially this code section.
Yeah, just like if you're stopping a vehicle and you walk up and look at
And
the
then you
driver's
see
license
something.
and you see something in the
Yeah.
back seat, right, that's a violation of the law, then you can move forward with that.
Okay. All right, thank you.
Thank you.
All right. I see no other questions. Thank you for your time today,
Sir,
Deputy
thank you, Mr.
Commissioner.
Chairman.
We'll talk about some of that dove hunting case law one day. No, I'm just kidding. I'm kidding. Yeah. Let's see, Mr. Mike Worley. Georgia Wildlife Federation.
That's it.
If you kill a deer and you don't have room in your freezer for it, I believe y'all have got a program that would take those deer, or it did at one time.
Yes, sir. It's called Hunters for the Hungry. We would be delighted if you want to donate. Anybody wants to donate a deer. We're even taking donations now from depredation permits. So
That's a non-paid plug, by the
thank
way.
you very much, sir, Mr. Chairman. That's a terrific, a very terrific advertisement. Mike Worley. I'm with Georgia Wildlife Federation. It's a pleasure to be here today. Thank you for the opportunity. I represent an organization. It's been around since 1937. We are the state's oldest conservation organization. I'm not here to speak as an attorney, so be gentle on me with the specifics of law. But I am here because we were formed by hunters and anglers. Though our tent is much larger today than just hunters and anglers. We have boaters and kayakers and bicyclists and all kinds of folks that enjoy the outdoors as part of our Georgia Wildlife Federation. I'm here today really to speak in favor of, I was forced to sign up as against or for, I say for, that's what it said on there. I'm really here to speak in favor of the current standard. Our hunters and anglers are comfortable with the way that our game wardens have enforced these rules and regulations over the years. And to be perfectly honest with you, we all recognize that what we see on the water is different. I think you used the word fluid earlier. It is a fluid environment on the fluid. It is truly a different world than what we see on roads. And we are here to just, or I'm here to speak to the professionalism and the courtesy that our state's game wardens offer to boaters. I hear that almost a regular basis, that our game wardens treat our citizens of this state appropriately. The reasonable suspicion standard on this case, because they are enforcing safety standards, much more than what you see by a police officer making a stop on a street. When a game warden, whether he or she pulls you over and boards your vessel, they're looking for things that keep you safe. They're looking for the things that keep the passengers on your boat safe. They're looking for your fire extinguisher. They're looking for your life preservers. It's a different interaction with those law enforcement officers than the interaction you oftentimes see on a public road. So I'm glad to answer any questions, but I just really wanted to say that we appreciate the work that they do. They haven't talked about this, but I often think when I see these law enforcement stops, these men and women are also not just the ones that do that enforcement stop, but if that enforcement fails on those safety devices, they're also the ones that have to go and recover. And so my heart goes out to them every time I see a story like that. And so they take the job seriously, as they appropriately do. It's appropriate that they take it seriously. And we're here to be here in support of the current standard.
Thank you. See no questions from members of the committee. Thank you for coming, being with us, Mike.
Sir. My pleasure.
All right, I think that's all we have signed up on this one. Yes. Oh, yes, sir.
I came in about 3 o'clock, so if there was a sign-up sheet, I must
Come
have
on.
missed it.
Come on. We adhere to the process in duty non-civil, so we welcome the public input.
I'm either an hour early or 2 hours late, one of the two. That's
All right, you showed up.
wonders of Atlanta traffic.
Yeah.
Good afternoon, almost good evening, everybody. Thank you for the opportunity to speak. My name is David Fuller, F-U-L-L-E-R, and I'm here today representing the United States Power Squadrons, America's Boating Club. Our group was founded
111 years ago about boating safety. And it's been about, from its very inception, about making the water safer for everybody. We do that through education and through a program that's actually a U.S. Coast Guard program called the Vessel Safety Check Program, where we go out and inspect boats where the boat owner voluntarily subjects themselves to that. We go down all of the legally required equipment, and if they have all that legally required equipment, we issue them a decal that they can display, and we suggest that they do this annually. In addition, we provide boating education that is to the NASBLA, National Association of State Boating Law Administrators. There's a national standard for a course, your courses. I also happen to sit on the NASBLA Education Standards panel nationally that actually writes those standards. That's one of the pieces of background. My other piece of background is about 25 years with the U.S. Coast Guard Auxiliary. I hold several positions with the Auxiliary, including coxswain and a whole bunch of other qualifications. We all trained to Coast Guard standards. And I just rotated out of an 8-year stint as the Director of Education nationally for the Auxiliary as well. But here I'm speaking to you as an America's Boating Club member, and we're all about boating safety, and anything that is done that moves us backwards in boating safety, we'd like not to see that happen. And what we know, since we don't do the actual stops, but we do I'll give a lot of advice to boaters when we're out on the water and we see somebody doing something wrong. Mentioned earlier about not wearing life jackets. You know, if somebody's under 10 years old, they're required to wear a life jacket. If we see that, we'll try and talk to that boater and explain to them what the law says, and we'll even give them a current book that explains it and lays it out in the law. So our mission is to educate boaters and to do prevention on the front end, as opposed to DNR and other law enforcement having to deal with the other end, which is making that phone call to the family saying that their loved one's not coming home. I've had a lot of interface with Coast Guard officers all the way up to 3-star admirals, and every one of them will tell you the very worst part of their job is when they have to pick up the phone or go knock on somebody's door and tell a family that their family member's not coming home today. And that's the toughest job that any of them face, and every one of them will tell you that, all the way from a junior officer all the way up to a 3-star admiral. And our job, if we do it right, is to prevent that from happening in the first place. So I'm here to support Georgia DNR in their position on this proposed legislation, and I'd like to let you know that you have a lot of volunteers out there that are trying to keep the water safer. You have paid people out there doing it, but there's a huge force of us in the volunteer world with America's Boating Club. We have 2 primary locations in Georgia. The biggest one here is in Atlanta, have about 250 members doing this work. And in Savannah, we have a group that's about 170 members down there that's doing the same work. So we're working alongside the Coast Guard Auxiliary to try and educate boaters and trying to make the water safer for everybody, so nobody has to make that phone call to the family and say your loved one's not coming home tonight. And that's all I've got to say today. Thank you very much.
Thank you. I see no questions from members of the committee. Thank you for fighting that traffic. I fight it every morning and every evening, so I feel your pain.
Thank you, Chairman.
Yes, sir. All right. I'll give Representative Ridley the final say, our closing statement. Officers, y'all didn't want to testify to it? I mean, y'all here. I mean, if y'all want to say something, be glad to have y'all. I mean, hold that thought, Representative Ridley.
Yep, I'm Colonel Mike England. I'm the Director of Law Enforcement for Georgia DNR, and currently been in that position for a little over a year. I've been 35 years with this department working boating safety. But I can say that some of the questions that you had here, This particular bill is not about, some of the things that go on beyond the stop. It's just the initial stop of the vessel, requiring the probable cause, before you could stop it. And like we mentioned earlier, this is something that he didn't come to us and ask, sort of how to make things better, because we didn't know there was really a problem with anything to begin with there. And like I said, since 2008, our policy has been, that our officers have some type of reasonable suspicion before they stop a vessel. And we address that with them. We wear body cameras and so forth, and we watch that. Our supervisors monitor that. And we've not had really any issues, with people stopping vessels that have not had any kind of reasonable suspicion. The probable cause is above and beyond what goes on for vehicles today. And so we feel like, if you require a vessel stop to have probable cause, then you're sort of tying our hands, as you've heard from some of the other folks here, about preventing things. For us, a lot of what he mentioned is we do education too. We teach boater education. And so a lot of times when we look at a vessel and we see there's a whole bunch of people on it, we don't know if they have enough life jackets. But if we're able to stop that vessel, here again, probable cause means that something would have to happen, a crime would have had to happen before we could stop it. So the reasonable suspicion is us, seeing a vessel with a lot of folks on it. We'll go over there and stop and talk to them and make sure they got enough life jackets for everybody that's on there. And if that vessel is short life jackets, then that could prevent a drowning later on that day if something happened. We spent the last 18 days working 12-hour shifts. I got 11 officers working 12 hours looking for Mr. Gary Jones on Lake Oconee. And I can't tell you how many times, that we're out there looking for folks. And not saying that there was a violation in this case here, but I'm saying we're constantly looking for folks on the lake. But what if we were able to be there at a certain time without probable cause, be able to stop that vessel and talk to them and say, hey, this might be an action or something that you need to address. I've explained it to folks for years. I would much rather pay a ticket than to lose a loved one. And when you try to explain that to somebody because, their kid didn't have a life jacket on behind a boat somewhere, it's much cheaper to pay, a $30 ticket at the county than to pay $5,000, $15,000 for a funeral. But for us, we need that ability to be able to stop vessels without the probable cause aspect in there. And like I said, since 2008, we have been using the reasonable articulable suspicion, for our folks to stop vessels. We don't just stop every boat out on the lake. We mentioned about marine toilets. Those boats are not even operating. Those boats are tied up at a dock. Aqualand and Holiday Marina are your world's largest freshwater floating marinas. World's largest freshwater floating marinas. And if we don't have the ability to walk on those boats and do inspections for marine toilets, then we have an issue there. There'll be a bigger issue environmentally.
Thank you, Colonel. You got one question from Chairwoman Silcox.
Just really quick, is there any progress with Gary Jones? He was my son's coach.
Is there any what?
Is there any progress with Gary Jones?
We are constantly looking. We're using aviation and we're using our sonars, and then we have our folks, out there every day. And then there are a lot of other volunteers there. But yes, like they mentioned before, it's a terrible thing for us to be in, to have to go notify people of that loss. Yeah. But we know how important it is to bring closure to a family, any family, regardless of who it is. But we're constantly looking, and we'll continue to look every day.
Thank you so much for your work and dedication. Like I said, he was a coach for my son, so it's personal loss.
Colonel, thank you for coming to testify. You have no other questions.
Thank you.
Thank you. Major, do you have anything you want to say? Okay. All right. Gotcha. Okay. I think that's all we got now. Representative Ridley, let's try that one more time.
Thank you, Mr. Chairman. And I'm not here trying to make the water less safe or anything. I just want to clarify that. And just some of the things he talked about. Well, I may not have talked with that gentleman about this issue. This issue, I've been having communications with the Department of Natural Resources for 2 years now. That started with Leader Abstration in his office 2 years ago. We started this conversation, and there's just been turnover at the Department of Natural Resources, so I can get why maybe some of them felt like I haven't been communicating with everyone. But to answer some of the things they talked about an underage kid on a personal watercraft. Well, if a 15-year-old's driving a car, that's illegal, and you don't see cops pulling over kids who just look young because they may be 15 or 16. So to say, when we're talking about parity here, then when they talk about hit and run, road cops have to deal with hit and runs too. So you have that parity as well. And then when like searching for life jackets, the road cops aren't pulling people over and making sure you have your seatbelt or making sure you have a spare tire in your car or things like that. So when they're talking about parity, they keep saying we need to do these things, but there's a road cop equivalent, and the road cops can't do that. So it's just trying to bring that parity there, and also protect people's Fourth Amendment rights. Like they talked about, they pull over a boat, they just pull it over without reasonable suspicion. They pull it over, they go see something else, or they can start they're opening up things. It's easy for an officer to start fishing at that point. We don't let road cops do it, so why should we let the game wardens? I'm not saying these gentlemen have ever done anything wrong, but there's bad actors out there and we see it all the time. So we're just trying to get make sure it doesn't happen and people's rights are protected.
You have a question from Representative Neal.
Thank you to the chair. Thank you to the author. So, quick question. So, you made a comment about road cops not needing reasonable articulable suspicion, in that you do.
No, I'm saying the road cops do have that.
Okay.
The code currently for them says they don't have to have that. So if I misspoke, that's my apology.
Gotcha. So I guess I want to get the intent. Are you trying to make it harder to get on a boat, or easier? Because this makes it.
I'm trying to make it harder, because right now it just says they don't have to have that. So we're trying to make it where they have that, trying to bring some parity to what road cops have. Because currently they're doing, these searches on boats. And again, another thing they talked about is the inability to do a roadblock. I disagree with that too. Anytime a boat goes in and out of the water, they're at a boat launch, they can tag boats when they come in and out there. They can tag boats when they come in and out of marinas, when they're coming in and out of the restaurants on the lake or the fuel dock. So it's possible for them to set up roadblocks at controlled points.
So I guess my question, when you say parity is equal.
Mm-hmm.
So, wouldn't parity for the boats be you have reasonable articulable suspicion to stop or make or get on the boat, and then the second level is if you're going to do anything beyond that general scope, you need probable cause to take further action if you want to make it.
And again, I'm not a cop or an attorney.
Okay.
But even in the code section now, they don't have to have articulate reasonable suspicion. That's what their policy is, but it's not required in code either. So if you'd like to make an amendment where that's what we strike it to make it parity, because that's the point of this bill, I'm perfectly okay with that.
I'll make that at the appropriate time, Mr. Chair.
I kind of feel like I've got to let DNR respond to that proposed amendment. I mean, what would that effect have on y'all? I mean, Colonel or Deputy Commissioner, whoever wants to take that, or both? I would assume this is established by case law already, but I mean, I'd like to hear y'all's opinion on it.
Sure. I think I had referred to Terry v. Ohio. That's kind of the national standard that we all work off of in the law enforcement world. Our current policy, as the Colonel spoke about and I spoke about earlier, is that we require that of our folks. While the law doesn't specifically say that, that is a requirement that we have for our folks to establish that reasonable suspicion. And we'd be glad to work with the author on what that looks like moving forward. It being our policy, we do have situations where that could cause some problems, but I'm sure we can work through that.
All right, I'm going to assign homework then. Y'all get together and figure out a standard y'all can live with. I don't know that it's going to be a tight schedule between now and 8 o'clock, and I got to let my staff attorney go home and get us some sleep and see our daughter as well. So may have to be first of next week.
Yes, sir.
But y'all get on that.
Thank you, Mr. Chairman.
Thank y'all. All right, next one I'm going to hear a former member of this committee. We're so sad you're gone now, but now you get to go back in the hot seat. House Bill 430, Representative Stephen Saines. It's not a shrimp bill, is it? Okay.
It makes no small impact, though.
Okay. I'd limit debate if there was.
Well,
go ahead.
I'm sure food is on your mind, Mr. Chairman, as we're approaching the hour of dinner. And as much as I would love to sit at a table. In that circumstance, I'll be quick so you can get to where you're going. If you don't mind, Mr. Chairman, Shelley Daniel, who is a technical expert in this area, is sitting along with me to answer to the committee's questions if there may be any in terms of application. But just to ensure that everyone has the correct bill, there's a substitute made to it, LC 481532S. This simply makes sure Section 1 and Section 2 are a little bit distinct. Section 1 clarifies that if you're if you are a sex offender in any other state, on the registry, actively on the registry, when you come to Georgia, that is an automatic reason to be on our registry. What we don't want is anyone feeling like there's a distinction with where they are and to where they're coming from, and feeling like they might be treated in a more in a different manner. In the same circumstance, we want to make sure that no one falls beneath the cracks, and that those doing the hard work of ensuring of looking back don't have to look back. We're going to trust that that state at a minimum made that determination. Doesn't keep us from determining on our own if someone's not on the registry that they should be, but it just gives that blanket protection to our citizens that those on a registry stay on the registry if they move here. Section 2 just clarifies that if a judge makes us that certain determination that that an individual can live in a different county in a restricted address, that we're notifying the constitutional officer that we put in charge of this registry at a local level, which is the sheriff. So that adds that mechanism to do so. Shelley, do you have anything to add in terms of just a general overview?
Sure, thank you. So I first would like to say thank you all for hearing from me today. I'm Shelley Daniel. I'm with the Georgia Sheriff's Association. I am the Director of Research and Information Services. I've been working with the sheriffs and sex offender registration for 10 years. So I appreciate Representative Saines for bringing this forward for us today. So in Section 1, like he mentioned, we just want to make it clear that if they were on the registry in the other state, there is no question that they would register here. So we don't have those falling through the cracks. One thing that I would mention is in the substitute that you all have, that we did have one change on line 27, and we'd like to make that and instead of or. That was our intent, so I apologize for that.
No, thank you.
And I'm happy to answer any questions that you all might have as far as the registry goes. Thank you.
Number 12, Chairman Gullett.
I like the bill. Last year we changed the sex offender registry. I'm trying to figure out, are there people coming here who are on a sex offender registry in another state who are coming here and there's something that's happened where someone hasn't feel like they've had to register, or a judge didn't believe they had to what's happened to cause this?
Yes, so there was a case that came out of Gwinnett County recently, and with that case, it was basically challenging in this current statute. It doesn't give GCIC or the sheriff or anybody the independent authority to just put somebody on the registry. So this kind of clarifies that language of what we believe was the original intent anyway, was if you're on the registry there, you got to register here. And it just takes away that, do we have to make the decision of, yes, they need to register here or not? And it allows GCIC to put them on the registry.
Yeah, I 100% agree with you. That is the intent, because I think last year changed the bill to say, or changed the law to say, not only are you on that registry here, but you can't come off that registry until you go there and get off the registry there. So, thank you for the bill. I can't believe that something that's like that's come up, to be honest with you. But thanks for catching it.
Yes, sir.
Chairwoman Silcox.
I guess I'm just curious, how does people self-identify? Hey, I was on the sex registry in 10 states. I mean, I wouldn't want to volunteer that information.
Right, so that's a great question. So there's actually 3 different scenarios that we find out about these people.
Okay.
So one of those is if that person is on the registry in the other state and they do it the right way and they let the other state know that they are leaving that state and moving here, provide the address that they're coming to, then GCIC will receive that notice that that person is moving here from the other state. That's a perfect scenario, no problems there. The other scenario would be that if that person doesn't notify the other state, but they just show up here and then they just show up at the sheriff's office and the sheriff's office had no prior notice, then they would go ahead and register that person, forward the information to GCIC for them to put them on the registry. The third scenario is those people that just show up here and we don't find out about them until they've either committed another offense or somebody recognizes them and it's brought to our attention that way. Wow. Great question.
Wow.
See no other questions from members of the committee. I don't have anybody signed up that I see, unless somebody slipped in at the last minute. Number 12. Okay, I'll entertain it.
Motion to pass.
Second.
All right, motion is second to do pass. All those in favor say aye.
Aye.
All those opposed, same sign. All right, you're up to full.
Thank you, Mr. Chairman. If I could add, the only pleasure of not being on the committee is I have a far better view of the members at this point.
Well, we can do that in full. Thank you, Terry. Appreciate that. Glad somebody's still awake in the back. No, I'm kidding. All right, next, let's go with Chairman Gullett. House Bill 447. I know, phone a friend, you know, you can bring whoever you need to help you out on this. Or you can present from right there, whatever you want to do. All right, go ahead. All right, go ahead.
Thank you guys. So this is, let me get the LC, sorry. LC 280681S, substitute. So, you guys have probably received a gift card at some point in your life as a gift. They're becoming pretty popular. And it's also a thing of convenience for gifts a lot of times. And so the convenience is also, I guess, really opened itself up to criminals, making it an easy and lucrative target. By being, you know, basically on organized retail theft and fraud. So what they do is they get these gift cards that are on the shelves, you know, at Kroger or Publix or wherever. They get a stack of them. They're able to remove the PIN information, collect the card information for the gift cards, seal them back up where you never knew that they had taken them, and put them back on the shelf, usually at eye level, so that because they want people to get these. Then when you go activate your card for, you know, grandma gives it to son for a birthday or grandson for birthday, all of a sudden they'll go and there's no money on that gift card. And this is really what's happening, really from a big organized, sophisticated group of criminals. And so what we're trying to do is make it easier for district attorneys to prosecute. Because really, if you think about it, at the time, if you get caught with a batch of gift cards that aren't activated, what's the value of those gift cards today? It's really not much, but really it is setting itself up for a lot of money and a lot of, you know, a pretty substantial sum of money, pretty substantial sophisticated criminal act. So that's what we're trying to address here. These people, you never know they were in the gift card. You never know that they had taken it. They sealed the PIN up, and it's just continued to grow. It's actually impacted retailers. They're the ones who bear the brunt of the issue. There's over $100 million in losses annually today. It's increasing because gift cards are increasing. So it's not just the big businesses that are suffering too. It's small mom and pop shops with limited fraud protections, and they take the hit often the hardest. And for consumers, you know, it's just embarrassing. You give your gift card and there's no money on there. Sometimes it's not said. And honestly, you get a gift card, I sit it on my nightstand until I'm ready to buy something. It might be 3 or 4 months away. Thing happened 3 months ago, 4 months ago. Oftentimes it's probably not even reported that it happened. You just think they didn't activate it or something messed up, and you don't want to embarrass them. So these scams are growing, and this really is just us trying to address that. So what it does on lines 33 through 40, that's really just creating 3 new criminal offenses. Acquiring, so 33 is acquiring or possessing a stolen gift card or redemption information with the intent to defraud. 36, tampering with a gift card, including altering packaging or codes to mislead consumers. Line 38, using deception or false pretenses to obtain gift cards illegally. Lines 45 through 53 establishes penalties based on the value stolen. So it creates a misdemeanor and up to a felony. And I think, lines, let's see, closes the loophole in existing fraud laws. So right now, Georgia has no specific way to address gift card fraud on its own. And so this is really just closing that loop. It's not another kind of card. It's really specific to gift cards. So this just gives a tool in the toolbox for prosecutors to rein this in and hopefully, stop these actors from acting. Happy to answer any questions.
All right. Looks like you got one. Number 11, floor 11.
Thank you, Chairman. Thank you. I believe somebody's going to testify to this, I believe, but how is this different than just transactional fraud that we already have on the books? And if on the second part is, are you stating that gift cards are different than your credit card, debit cards that could be stolen, and if so, how are they different?
Yeah, so I think one, a lot of times the value of the cards when they have them. So if I got pulled over and I had a stack of gift cards in the back of my car that weren't activated, today what is the true crime other than I stole some plastic, and what's the value of that crime? The crime, say the value is $3 of plastic that I stole because it's not activated. You're not actually activating these cards. You're setting up the process of theft. And so I would argue that gift cards are a little different than a debit card, because there is literally like because of that situation, there's no value there that you have, and you don't add value to it. You steal the value once it's actually done later in time. So it's really preempting the crime before it really happens. What we're trying to address here, stop the crime. And when you do the crime, you should have a tool for prosecutors specific to gift cards. I think there's already fraud related to regular cards, but it's specific to gift cards, just to be very clear, so they can prosecute. Don't know if that answers your question. That's the best I got. Hopefully they answered a little bit better, but it's really specific to gift cards.
Thank you. I'm going to think of things. I'm going to think. Thank you.
I'm not saying anything about crayons today. Let's see, Representative Neal.
Thank you to the chair. I did have a question. What is the difference between this and the 2005? In 2005, we passed a law related to people who buy and receive gift certificates and gift cards. It's called the Gift Card Integrity Act of 2005. Is there anything there? The code section is 10-1-393.
I have no idea what you're referring to. I'm sorry.
Okay. Okay, that's all I got.
Thank you. Number 7, Representative Holly.
Thank you, Mr. Chairman. Chairman Gullett, I was wondering, it kind of actually quite similar to Chairwoman Hong. Is there a need to, I guess, put it under its own section, this 964? Because, I mean, wouldn't this come under 16-9-33? Being it's a, like if the officer's going to charge, prosecutor's going to charge, they could do you can do financial transaction card fraud. I mean, shoot, if you want to, up the stakes, you can do 16-9-121 identity fraud, right? Like, couldn't this come under financial transaction card fraud, which is currently on the books? It's just like kind of a subordinate.
Well, I think that they are trying to prosecute today. I think they're having some difficulty prosecuting. This is a nationwide issue that they're trying to tackle. FBI has flagged it as one of the large, increasingly financial transactions, and so it's really just to clarify specific to this issue. They're pretty. I think people testified. These folks are really agile and sophisticated, changing their processes. Everything they put in place, where they put geofencing in place or all kinds of different things, they were working around it within a couple weeks. These aren't just your average, petty theft criminals here. These are very sophisticated people, and prosecuting it, this is just an opportunity, another way for prosecutors to prosecute it. So, I mean, are they prosecuted today? Yes. Are they struggling to prosecute it today? Yes.
Oh, yeah. No. I wasn't saying the struggle in that. I'm saying that literally, like, the people who are found guilty of violating 16-9-33, the same attributes of their criminality can be explained under that code section as well, and they're being successfully prosecuted for that, which is why there's not been a repeal under the books. I'm just saying, like, literally, because that criminal enterprise can still be specified as being a a kind of a bottom level rung of financial transaction card fraud, which we already have. That's all I was just saying. Okay.
You might have an answer coming from Chairwoman Silcox.
So I just want to understand, Joseph, what you're saying is that the reason this is different is because when you purchase a gift card, it hasn't been activated. And so you have nothing but the plastic, like you said. But until the person who's the recipient of the gift card activates that card and sees that or discovers that there's no money on it, there's really no one knows of the theft.
Right, the theft is
and
hidden.
so
Right.
that's why the gift card is different than a debit card or a credit card, because the credit card and the debit card are live once you have them, or I guess you have to call the 800 number to verify that you received the card. But
Right.
but the cards are active all the time. You don't have to routinely activate them to get any value out of them.
Right. Yeah. When you get that
So-
card off the register and you activate it, there's no value. They steal it. There's no value. They put it back. They capture information. There's no value. They put it back on the shelf.
Right.
There's no value. And once it's activated is when they ping it, immediately get the funds from it.
So you're
It-
you're actually trying to catch these people before.
That's right.
All right. Number 6, Representative Neal.
Well, granted, I haven't wrote this code section in a long time, but I thought, so credit card or gift card, is still, the value is either nothing or whatever that is. The crime happens based on how much you steal from said card. Okay, so I'm trying to clarify some of the comments that people are making. Okay, I guess I just feel like people are trying to we're just trying not to duplicate pre-existing.
Sure. Yeah. I think right now, I think I would say the current laws are insufficient. So we're not trying to duplicate it. There's just insufficient laws to prosecute this type of crime that hasn't really been thought about. Used to be, we had gift certificates. Then color copies became very popular. And so gift certificates became easily forged and copied. And so gift cards became there. Now, gift cards are, there's ways that these folks are stealing the money from those. And I think probably, to be honest with you, Chairman, I think we have some testimony here from some of the folks that might answer some questions, and I'm happy to continue to answer questions after that, but might be a good time.
Well, Floor Leader Hong, you want to go ahead and ask yours?
Thank you, Chairman. I'm going to throw this out, and Chairman, if you want to tag somebody, that's fine. I'm trying to think through this. So, if you are arrested for let's say you steal my credit card, and you use up $1,000 of my credit card, that amount is going to determine whether it's a misdemeanor or a felony, depending on how much you've used. I understand that a gift card doesn't have value, and I think that's kind of the definition when it comes to transaction fraud statute, that I understand the gift card doesn't have a value until it is activated. But if you are arresting somebody just for the mere holding of gift card or gift cards without having actually used it, then how are we prosecuting it? And are we prosecuting it as the maximum amount of the gift card? Are we without them having used it? That's kind of, I'm throwing that question out there if anybody can answer it. Right, but if they haven't used the gift card,
but they've already
see,
stolen it by the
if they
time.
haven't stolen 500, let's say the gift card is worth $5,000 and they haven't activated it, and they haven't used, and or they haven't used it, then how are we going to know how much that person, now you're just assuming how much would that person have stolen of the $5,000 gift card? Because some people do, steal debit cards, credit cards, go to Walmart, purchase things. Doesn't mean that they max out the cards. And so it's a value of how much they stole versus what was the maximum limit on that card.
So
If that makes sense.
Yeah, in number 8, line 30, it talks about the value of what we're defining the value as. Doesn't mean that's necessary, but basically it's the means the greatest amount of economic loss the card insurer, gift card seller, card holder might reasonably suffer, including the full or maximum monetary face or load value of the gift card, regardless of whether or not such gift card has been activated. So
we are stating that no matter whether that person could have stolen $5 of the $500 gift card, or
they set the trap to steal they set the trap to steal $5,000. They're kind of they're on the hook for $5,000 because that's what they're doing. They're stealing this. They're capturing information for it. But again, I think they'll answer some questions and maybe clarify some things that I'm not.
Sure.
Okay. We've been in here a while. We're going to take a 5-minute restroom break. And I mean 5 minutes.
5 minute toes.
Okay. All right. I believe Representative Neal had a question. She's still. Representative Neal.
Yes. Thank you to the chair. So I guess my question for the author or concern would be, because this isn't aligned with how we currently handle card thefts. It comes off as though people are being charged or arrested for something before they actually did the crime. So for instance, if say it's a gift card that has $5,000 on it, and being an officer won't know that. So when they arrest somebody, say they have 10 cards with $5,000 on it, that is however way they received it, theft by taking, for instance, times 10, right, for the cards, because you don't know or have a value. And then it's not until you swipe and the charge aligns with how much you spent. So what I'm saying is right now this bill looks like we are adding a value to a card that technically doesn't exist and is not in line with how we currently handle these cases. And so I'm just trying to get the balance because, like I said, if you have 10 cards, it's theft by whatever. And there's no value there until you swipe. And so that's my biggest issue with this. It's like we're arresting and penalizing people for a crime they have not done yet as far as the spend.
Sure. So I understand what you're. So I think you're thinking of this as a little one-off thing that's happening when this is really like organized crime doing hundreds and thousands of these cards at one time, stealing stacks of cards, and so it's not like my neighbor, doing this one time. This is they have stacks of cards, and so once they get the money, once the crime is committed, it's gone. There's Chinese syndicates out like cartels that are getting this money and it's gone. And so what we're trying to do is give our prosecutors and sheriffs the ability to stop it before it's gone, because ultimately once it's gone is over. It's too late. And so really you got to think about it, I think, a little differently than everything else, because it really is. It's too late. They're setting the trap. So although they haven't stolen the money, they're taking an action to set the trap to steal the money. And so it's like if I broke into a store, and this is a bad analogy, I haven't even thought it through, but I break into a store, I'm outside, I got the things for the theft, but I actually haven't stolen the jewelry from the store. Like I've taken this. It might not even actually be a bad one, but I think it's just different than anything we've ever seen. I think we're just having to think about it a little differently than something that we've seen before. It's just not. It's not something.
Yeah. Okay, so I'll jump in. Yeah, that is a terrible analogy. So, if you go into the store, we'll charge you with going into the store, and we're not going to say that you stole $1 million worth of diamonds
yet, I get it. It wasn't
until
bad.
you steal $1 million worth of diamonds.
Yeah.
So I'm just trying to make it fair. I think I understand what you're trying to do.
Yeah.
But I don't know if this is the way to get there. And I fear this having a lot of unintended consequences just because of how it's written.
All right. Number 7, remember, question on, we'll get a discussion here in a while. We got some folks signed up to testify to this. Number 7, Representative Holler.
I'll make it quick. Thank you, Mr. Chairman. I liked the example, the analogy that you gave, so let's say you go and you break in, you break into Lenox Mall, and let's say just for happenstance, you break into like American Express, and somebody takes a bunch of black cards, right? We all know like those black card, the Amex is like a $2 million, potentially that you can get off of there. But you go in and get them, and they're not activated. But let's say you activate one of them, and on that one, you buy a $2 Starbucks you know, nothing Starbucks is $2, like $20 venti coffee or something, right? Then officer will charge you, and the prosecution will totally charge you with breaking and entering, right? You definitely get the breaking and entering on you. If you're stealing property that's not yours, then that's, you know, that's a theft by taking or theft by receiving stolen property, right? But then, like, the actual amount in terms of that you actually purchase, that value itself, that value, you're charged that value. But the thing is, you're not going to get charged at $2 million for that card because you only spent like $20. And so I think that's the thing is that I can understand that, you know, trying to make a case for RICO, maybe, you know, for these prosecutors to go big, but like if a prosecutor, if you can't prosecute this off of basic theft by taking and then the actually activated amount, then you're actually,
but we're trying
to be a bad prosecutor.
I'm going to interject,
Okay,
Representative
go ahead.
Holly. This sounds like it's going to be for discussion. This is questions.
Sorry, Mr. Chairman.
No, it's okay. It's okay. No problem. We've got people signed up. I'll let y'all hash this out in discussion here shortly. So we're going to move on to our witness list. Let's see. We have Ben Cowart.
You will go first.
Fierce things.
Ben Bryant, then.
There we go. So, Chairman Smith, and members of the committee, thank you for the opportunity to testify today in support of House Bill 447. I'd also like to thank Representative Gullett for sponsoring this important piece of legislation and giving a great overview of what we're looking to do here and some good solid background on what the issue we face is. And you guys have asked some really thought-provoking and great questions, and I hope as part of my testimony I'll answer those, and if not, certainly you'll take questions to help run that information to ground. My name is Ben Bryant. I serve as Vice President and Senior Division Counsel at Incom Payments, which is a global payments technology provider headquartered right here in Atlanta. We've been a leader in the gift card and prepaid industry for over 30 years, operating as a program manager and third-party distributor of gift cards. We have a presence in over 525,000 points of retail and online distribution, 412 global patents, and a presence in over more than 40 countries. As it's been noted over the last several years, the retail gift card industry has seen an increase in gift card fraud, with criminals becoming increasingly more sophisticated. HB 447 would help law enforcement by modernizing and enhancing Georgia's existing criminal statute to enable prosecution of gift card fraud. Many states, including Georgia, have outdated criminal statutes that don't contemplate how fraud in the gift card space has evolved in complexity, and as I think we've seen from discussion so far here, how it differs from other types of fraud with other types of financial devices. We regularly coordinate with federal, state, and local law enforcement agencies to help identify gift card fraud trends and aid them in catching criminals. And one of the recurring themes that we hear from law enforcement is the need for updated and modernized criminal statutes to allow them to do their jobs to prosecute these bad actors. We believe that HB 447 will enable the prosecution of specific types of gift card fraud, such as card and package tampering, the unauthorized receipt and use of stolen redemption data, and instances of victim-assisted fraud, where victims are defrauded into purchasing gift cards for the criminals. I was going to say you might be questioning why this legislation is necessary, but you already have questioned that. So while law enforcement working in collaboration with industry has found ways to prosecute gift card fraud, there are obstacles with the current law. Currently, Georgia's law does not explicitly criminalize gift card fraud, and existing criminal statutes, those that talk about financial transaction cards, as referenced earlier, they don't cover this type of fraud, and they don't expressly call out gift cards, which is, as we've talked about here, are an own unique animal in terms of how they operate and where the value lies. Basically put, they're not the best fit for prosecution of these specific types of crimes. And we believe that legislative action will strengthen the protections, enhance law enforcement capabilities, and impose clear penalties for those engaged in gift card fraud. As it's been alluded to, recent gift card fraud trends such as card tampering and draining, these are not, a 16-year-old kid walking in and stealing a couple gift cards. These are highly sophisticated state-sponsored Chinese crime syndicates that are oftentimes working on behalf of the Mexican cartels to steal gift card packaging, to steal the gift cards, walk into a Target, steal the gift card packaging off the rack, take it away. They have mules, just similar as drug mules, take those back to a warehouse, unseal the packaging, steal all the data off of the packaging, have folks, reseal them and put them back so that an unsuspecting customer would go in, buy that card, and then they constantly check with balance checking capabilities, pinging the numbers to wait and see when those cards are activated. And once they're activated, they immediately drain the funds and spend those funds on large ticket items that they ship overseas, or otherwise use the proceeds of those cards to further money laundering and other illicit activities. Highly sophisticated industry. We continue to evolve. It's been 30 years plus of constant enhancement to our technologies at our packaging as well as operational level to thwart that. But as sophisticated as we are, the criminals are unfortunately just as sophisticated. And we're constantly acting to disrupt their success and their schemes through advanced technologies and with the point of sale activation, real-time fraud monitoring, and improvements to packaging, as well as consumer education, training for retail clerks, and otherwise. And while innovation is important for the gift card industry, what the steps we take, what our retail partners take, it's equally important to have that third leg of the stool, law enforcement, be able to do their jobs and effectively prosecute these criminals and put them away so they don't continue to perpetuate these types of crimes. So thank you for the opportunity to address the committee today and provide my support for HB 447. And if I may, I'll try to answer a couple of the questions that were raised. Let's see. Representative Neal, I believe you asked about Code Section 10.1313 from 2005. 393, sorry. That is a, I can't read my own handwriting. That is more related to what I kind of the state version of the federal UDAP statutes, unfair and deceptive acts and practices. So it's designed more to focus on consumer protections and unfair and marketing practices and things of that nature. So it doesn't touch on the gift card fraud that's happening here, which that has been pointed out is similar in nature to, and what we're looking to do is add some additional language into the existing financial transaction cards section that is inadequate today. Both in terms of not expressly talking about gift cards, not adequately addressing the value of said gift cards, and not covering the types of activities like package tampering that are prevalent in this space that aren't for other types of financial transaction cards. So think of it more of as putting another arrow in the quiver of law enforcement and prosecutors to go after these types of criminals. The value, we talked about value. So when there's a gift card hanging on the rack, you have fixed denoms and you have variable denominations. So fixed denom, $25 Starbucks card, $100 Visa card. You might have variable denoms, which it could be $20 to $500 MasterCard gift card, right? So you'd say, well, I want $150 to give to my son, so I want to activate this one for $150. So there are values associated with those cards, and I think that's one thing everyone, including law enforcement, struggles with is when they catch someone with that duffel bag of 1,000 gift cards that they've stolen from 15 different area targets. To us and into the victims of the crimes, I'd go so far as to say as law enforcement trying to prosecute these, the value certainly extends beyond the $1.50 that it costs, the piece of plastic to manufacture the card. There is value associated with it, and that minute that card is activated, those funds are swept off, and whether it's a $25 card or a fixed denom or 35 or whatever that denomination is, that's the amount that's going to go. And the intent is that just like we'd want to catch someone committing other types of financial transactions crimes before they get well down the path and that money is long gone. We want the ability to stop those folks and catch them red-handed, so to speak, and be able to put them away before they perpetuate that and before innocent consumers become victims of that crime. And that's, I think, there was other questions I probably haven't touched on yet that you guys raised.
We can get into that. Representative Neal.
Thank you. I'm going to try to be brief. So I guess first, yes, the denomination, that would make a difference. So if you have something that says, yes, this is $25, it's different as opposed to those gift cards that don't have a value at all or aren't loaded yet. And so this doesn't speak to those differences, one. And two, so since my issue tends to be with people being charged before with a value of something that they haven't even taken yet as far as spending, what I see is the ability to make it where theft of a gift card, just having it without spending it, could be a misdemeanor. And then any person that does anything beyond theft, to include altering, tampering, and all the other things you kind of mentioned, that makes it a felony. For me, that could be a fix, because we're removing the aspect of, charging people for something they haven't done yet. But I would love to hear your feedback on kind of those things.
I know that the Prosecuting Attorneys Council is going to speak on some of the sentencing guidelines. We had a chance to speak out in the hall earlier before we got going here, because we want to make sure that what we put together is something that they can prosecute on. Because if they can't prosecute on it, it doesn't do anybody any good, right? I mean, that's the whole thing we're trying to fix. So, I would leave, and we have some ideas that we've talked about that might fix some of that in terms of the sentencing. And but as far as I think that the value concept, that is the big thing, and that's what we keep running up against. I think what law enforcement runs up against is that it's a misnomer. It's from our point of view, right? It's not accurate to say that it doesn't have value until it's activated, because there is some value associated with that. That once it's activated at the point of register, it is lit up in that amount, and those funds are immediately drained. So I 100% hear where you're coming from, and that's kind of what we're struggling with, and what I think law enforcement is struggling with is, right, the criminals have set themselves up to be able to commit that crime in that amount that's activated, which if they have a stack of $100 gift cards in their possession, and those funds will be drained off as soon as they're activated, they effectively have 100 times $100, right? They don't have 100 times $1.50 for the plastic, and so these criminals are getting away. These state-sponsored, sophisticated money laundering organizations are not being able to be prosecuted to their fullest extent because of that disconnect, and that's what we're trying to put in place. That basically, these cards do have value, and what that value is the maximum amount of value that can be loaded on those cards at the time that it's activated, and those funds are drained by the criminals.
Okay.
No more questions, thank you. All right, next up, does the other Ben want to talk now? Mr. Ben Cowart.
I'll be brief. Figured I'd let the attorney go first. Thank you, Mr. Chairman, members of the committee. My name is Ben Cowart. I'm Vice President of Government Affairs at Georgia Retailers. Georgia Retailers represents businesses large and small across the state, have done for over about 60 years. I want to thank Chairman Gullett for bringing forward HB 447, which we feel provides some essential protections for gift card theft, forgery, and fraud. So this has been kind of an increasing concern for our members really over the last several years. It's really picked up. It's harming consumers. It's harming businesses and kind of the overall Georgia's retail economy. Criminals are using stolen, manipulated cards to launder money and defraud retailers. And I think it's important to understand this is a very unique situation. So these criminal organizations, they have a group of people that are kind of like guest boosters in regular organized retail crime. So they're sending out these groups to go steal thousands of cards off of a rack somewhere, take them back to a place, they tamper with them, steal the PIN numbers off of them, load them onto digital wallets. Then those same people come and put them back in a different store for the consumer to buy. So then they're loaded in the digital wallets. You've got somebody sitting in a computer server room that's just constantly checking. So when you go buy that gift card to give to your spouse or whoever, and you tell them, I want to put $200 on this card, that person checking it, it shows up that it's on there. They shoot it digital wallet. They send it to another group of people that are running out and buying something, usually high dollar items that they can sell overseas. So it's kind of three different groups of people, and what we're trying to get at is the groups that are going out and stealing the cards prior to tampering with them, and then are going back out and placing them. So it's kind of a very unique situation. We're trying to help prosecutors in being able to prosecute this kind of very unique type of crime. And from the retailer standpoint, we've been doing a lot of things, actively working to prevent this fraud through strategic partnerships, technological advancements, consumer education, We are constantly collaborating with law enforcement, federal, state, and local to kind of disrupt these criminal operations. We have a group called the Georgia Retailers Organized Crime Alliance that is loss prevention people from inside retailers and law enforcement that work together. We meet monthly to share intel and pictures and whatever we have of these groups that are kind of moving through the state. Another example of law enforcement collaboration is a thing called Project Red Hook, which is with Homeland Security. It's a nationwide initiative targeting this abuse of retail gift cards by organized groups, and several of our large members are involved with that. That's resulted in over 150 arrests since January of 2024. So this is, like I said, it's a new evolving kind of issue for us. We're also implementing advanced security technologies such as geolocating, so they can tell if a card's been moved from one store to another. They're doing tamper-proof packaging and kind of encrypted pins. We're going at it every different way, but I hear from our loss prevention people, within a week or two of implementing a new thing to try to combat it, these groups have figured it out and they've got a workaround on it. So really, I think the premise of this bill is just trying to figure out a way that we can try to address this from a criminal standpoint and give prosecutors another tool. So I would just say that we appreciate the chairman for bringing the bill. We feel this will help prosecutors in addressing this issue and ask for your favorable consideration.
Thank you. No questions from members of the committee. All right. Let's see. I think all I have left is Robert with Prosecuting Attorney's Council.
I have law. I don't know if I have answers.
We like law.
Yeah.
We love law.
Here's the thing that what's going on and why this bill's here. When you go into a store and you see, as has been alluded to by one of the bins, that the piece of plastic is $1.50. And if we, as working with our law enforcement partners, can't establish that it's been through the, when you buy a gift card, you have that little extra minute or two where the machine cycles and gives you the little itty-bitty receipt. If we can't show that it's been activated, we don't know what its value is. So if we can't see what its value is, it's worth $1.50 and something else. It's just a piece of plastic, whether or not, or you can ask a law enforcement officer to spend the time to track it down and do all those things. And that's part of the problem we have in the code section, because we have gift cards, we have store valued cards, we have so many different ways of how we refer to these pieces of plastic and what they can do, because they also are magic pieces of plastic. I mean, gone are the days where your grandma and granddad put the $20 bill in the birthday card and you got excited. No, now you get a $20 gift card to go to your favorite restaurant, or to go to your favorite store, or go to the movies. That's how we've kind of changed things. We don't put cash we really don't have cash anymore. So what this bill does is it does assign a value. It does say these pieces of plastic have value to them. So then we can start working with a standard knowledge and a standard definition. The other thing too, and one of the points that you brought up, Representative, was about the example of going in and getting blank credit cards. These and that's one of the differences between these gift cards and the store value cards, credit cards. There's no account number assigned to it. And that is why it's different than the green dot cards. It's different than the Visa stored cards. These cards have intrinsically, you use up the $25 at Starbucks. If you want to, you can add value back to them, or you can chunk them and recycle them or do what you want to with them. Some of those cards are designed because of the account for you to keep putting money back onto them. It's a benefit for some people who can't get credit cards. So they but need a card of some type where they can make major purchases off of, or pay their rent, or things like that. That's one of the ways why these things came about. So what this bill does is it fills in a bit of a hole. as you know, I really respect my boss, Pete, and we always talk about how if you want to give us a crime, take one away. We need to have a longer conversation about fixing the financial transaction card portion of the statute, but that's not today. That's not for today. For today, this bill fills a hole. It does provide us with some things. There's a change that I've asked, and I believe the chairman's okay with us making. What we've done in parallel with some of the theft crimes is that you've said, hey, the first time you do this, it's a misdemeanor, but then after second or subsequent, it becomes a heightened punishment. And that's one of the things I talked to the advocates, and I apologize, I haven't had a chance to speak to the sponsor. But if we're not going to do something, one of the problems is that if you tell people, okay, if you steal $500 or more, it's a felony, then they're going to go in and we know this, and I know that people don't always accept this, but if you tell somebody, if you steal 500, it's a felony. Well, if you steal 490, it's not. So they'll go in and they'll measure 490. Just like we've seen people weigh drugs to know that they're under the trafficking weight. Just like we know when we're driving on the interstates, if we're only 8 miles over the speed limit, we might not face the same sanctions as we were 16 over. Not to say that anyone in this room has ever done that, but people know the limits. And that's why the ask I've got is that rather than simply saying for every time you do 500 or less is a misdemeanor, make the second one, make the third one. That's a policy decision, but my ask is that you make a felony for multiple offenses, because, and I'll close out. I know the hour's late and we've got a lot to do, but misdemeanors mean that we cannot do RICO, we cannot do gangs, we cannot do asset forfeiture. So that's the other reason why I'm asking, because that is one of the differences. Financial transaction cards, you touch them, it's a felony. If this bill continues on with the process, you've got a misdemeanor built in. So that means the first time somebody does this, those things, including the Attorney General's organized retail theft or unit that he's trying to stand up, wouldn't really get involved with this. It will still be your local prosecutors, your part-time solicitors will be prosecuting this. And so let us have a felony for a second and subsequent. That's my ask. And I'll answer any questions if I haven't already answered them.
Representative Holly.
Just real quick. The point you made about how this modernizes it, because back in the day your grand folks would just put money in a card and send it to you, right? The thing that I'm just trying to gather around in my head. Let's say you are the recipient on one of those cards, right? Like, it's a gift card. Like, literally, you're getting a gift, like a birthday gift card, right? How are we differentiating? Like, what's that threshold that makes you a criminal in receipt of it to one who's actually stealing these from a store, taking them home or wherever you are, changing the numbers on them, and then putting them back out there? Because you probably, if we're looking at criminality, mens rea, you probably are really guilty if you're doing one of these manufacturers put it back out there to the difference of I'm just a recipient. My grandma gave me a card and it just has it in there, but I'm using it.
Yes, and that's part of the policy you're making in here, but also how the person comes into possession of it. Because if you've got it and I push you down and take it from you, we're going to call that robbery.
Right.
If I put a gun to your head and take it from you, we call that armed robbery. If I break into your house and take it from you, that's burglary. So there's several different ways, several other crimes that are encompassed by this. This is primarily designed for the people who come into the convenience stores, who come into the grocery stores and grab them off the rack and run off with them.
Gotcha.
Thank you. That's all the questions I see.
Thank you.
Charlotte Davis, you want to say anything?
I'm good. There's nothing that hasn't been said, Mr. Chairman.
Okay. Mr. J. Morgan.
Good, sir.
Okay. All right. Did I miss anyone? Okay. All right. You want the final word? Okay. All right. Any discussion from members of the committee? Okay. What say the committee?
second. I guess with the proviso you're going to get with the staff.
The amendment? Yeah. You had the amendment too, those, right? Did that give you? Okay. Yeah. You would pass it now.
Move do pass in a second. Any amendments? I understand y'all may work offline on this. All right. Move second that the bill do pass. All those in favor say aye. Aye. All those opposed, same sign. All right. So get that fixed done. Maybe Monday on this one. Okay. Next, we have House Bill 10, Representative Kim Schofield. Schofield, I'm sorry, Kim. It's late. All right, go ahead.
Good evening, Mr. Chair and members of the committee. I thank you for allowing me to present this bill. I'm presenting to you, I'm going to give you LC numbers first because it's a little difficult. A substitute, LC 48125S, which was actually a bill that was submitted under HB 882. Yeah. Oh, I'm sorry. Okay, and it's actually the bill that I have submitted. The same bill version is LC 481353. Yes.
Hold tight. We do not have that substitute.
You have. This is the substitute that you did.
Last year?
So that's last year's bill to pass down. I have that ready, but I haven't seen that.
We'll suspend for just a second.
Yeah. That's when I. Okay. Are we good?
We will be apparently the gentlelady will be amending her. Excuse me. The gentlelady will be proposing to this committee that what we are passing out be the substitute language, which is the language that Representative Roger Bruce had from last year.
So replacing the current language with this language.
Yes, in the sub.
I got you.
Thank you.
All right, you may proceed.
Okay. The name of the bill is the Georgia Booking Photo Privacy Protection Act. And it's really a procedural change. In Georgia, when someone's arrested, their booking photograph, commonly known as mugshot, is taken. But what happens when a person is never convicted, when charges are dropped, or when they're found innocent? Unfortunately, their mugshots remain public. And in today's digital world, it really can mean a lifetime of harm. So I've got a few people that are say a few things about the bill. And I'm going to bring up Graham, if you'd come up, Graham. The substitute. This is LC. Yeah. 48125S. 125OS.
Thank you, Chairman, and all the members of the committee. I'll be very brief, talking exactly about the substitute, the language from Roger Bruce, LC 481250S. GACTL's comfortable with this language. We believe that it has been vetted and that it strikes a balance. There'll be other people that talk about the First Amendment, but essentially between the principle of being innocent until proven guilty, while also making sure that a potentially bad situation can be fixed here. And I would like Carlos, one of our lawyers of the week, to quickly talk about how he sees this in his practice. I can just move here.
Go ahead. Good to see you again, Carlos.
Good to be with you. Thank you, Chairman, members of the committee. So my experience with this and this bill would really focus on the those predatory businesses that are profiting off of publishing these mugshots. This doesn't apply to the AJC or the Associated Press that is publishing a news story with a mugshot of a recent arrest of what is deemed to be newsworthy. But this is talking about these like clearinghouses that are charging people a fee to suggest that they will remove their mugshot if you pay this fee. And then what ends up happening is these clients will pay that fee, and then the mugshot stays up there. They get caught up in this hamster wheel of trying to remove their mugshot when they haven't been convicted, and these businesses are putting themselves out there as willing to accept their money and take it down, and then they don't. So we'd ask you to pass it. Thank you.
See no questions from members of the committee. All right.
Make a motion to pass.
Move to pass. Second. Yes. Yes. Oh, I'm sorry, Reagan. Sorry, Reagan.
Sorry about that.
That motion's out of order by ruling of the chair. I'll come back to that.
May I, Mr. Chairman?
Yes, sir.
Mr. Chairman, members of the committee, I'm Reagan Marsh with Troutman Strategies, represent the Georgia Press Association. So the original version of the bill made it so that a newspaper or any other media organization could not publish a mugshot if the person hadn't been convicted. I'm reading this one right now, and I think it does the same thing. If that is the intent, I'll offer some caution there. There may be a situation where a mugshot of someone who has not been convicted of a crime is newsworthy, and I'll give you one example, like a public emergency, where someone has been charged, let's say with murder, is in jail, has not been convicted, breaks out of jail, gets a gun, and is running through Atlanta. I mean, at that point, if you got a mugshot, I would think law enforcement would want to get that out to the news publications, whether it be print media, website, or broadcast. And I know the original version of the bill, in my opinion, would prevent that. I think this one might too. I need to read a little closer.
Look at line 67 through 69.
That solves that problem. Got one other issue for you. There may be some scenarios where a mugshot, even if a person hadn't been convicted, would be newsworthy. The Press Association would like you to consider the fact that, it helps identify people. And if you've got someone with a similar name, a photo sort of answers the question of who it is. It may be a public interest if it's an elected official or someone that has been arrested. It may be of interest if you're an employer and you're thinking about hiring somebody. If there's an arrest booking that you can find, there's not a picture, it may hurt the person trying to get the job if that wasn't the person arrested. So while the Press Association supports all of these laws that deal with remove for pay, and they support strengthening the laws, they still believe there are times when a mugshot is newsworthy for a legitimate news organization. Thank you, Mr. Chairman. I can answer any questions.
I see no questions. Thank you, Reagan. Sorry about that.
No worries. Thanks.
Carl, you got a last name just for purposes of the record.
Chris.
Last name.
Oh, can I just be anonymous?
I'll allow it, Carl.
First of all, thank you for all of your time. Good afternoon. My name is Carl, and I'm an engineer who graduated with highest honors from Georgia Tech in 2017. With my skills and education, I should be working in my field, contributing to society, and earning a living. However, because of an arrest and a mugshot that appears in a Google search, I am struggling to find employment. I was lucky to have 6 years of employment right after graduating, but I work in the tech industry, and as you are familiar, it's just been like layoff after layoff for a lot of people in tech. So the reality is that my job search struggles didn't start with this arrest. It started about a year before it happened. And the arrest has just made it even more incredibly difficult. Like many others in my field, I was already facing a tough hiring market, sending out applications with little responses. Once my mugshot started appearing in a Google search, my chances went from difficult to nearly impossible. The arrest was the final nail in the coffin. I found out about my mugshot only a few weeks ago, and in the worst way possible. A close friend of mine from high school here right down the street had referred me for a job at a blue chip company here in Atlanta. And after referring me, his boss asked him how to spell my name. I have a very unique name. And this is partly why I didn't want to say anything. Even my friend forgot how to spell my last name, so he Googled my name, saw my mugshot, and basically told me he could no longer vouch for me, not because of my skills, experience, or work ethic, but because of what he found online. It was devastating. This was a close friend who had known me for years. I was finally getting an opportunity to get my career back on track, only for a mugshot to take it away before I even had a chance. I have a unique name, and even searching for partial parts of it brings up that mugshot, making it nearly impossible for me to move forward. What's worse is that this isn't just affecting me, it's also affecting my family. I have a younger brother who is also a student at Georgia Tech. I look after him. And seeing me in distress over this situation is not good for his mental health. He's already dealing with the stress of trying to find a job in this competitive market as he approaches graduation. And now he has to watch his older brother, someone who he looks up to, struggle with something that should not define my future. On top of that, not having a job has put me in a serious financial crisis. I've had to deplete the majority of my savings just to cover basic living expenses and the legal fees associated with my case. Every day this mugshot remains online, my financial situation gets worse. Instead of contributing to the economy and using my skills to help businesses, I'm just barely getting by with the help of my savings while I drain my resources. I want to acknowledge something important here, which is that I'm, one of the few people that will be speaking on this side of the bill, like from a testimony. But I know that I'm speaking on behalf of thousands of Georgians who are in my position, those who may not have the time, which is a privilege, to come here and speak on their behalf. Those who have lost jobs, lost opportunities, and lost their futures because of a system that allows mugshots to define them before they've had their fair day in court. They're not here today, but their struggles are real. What makes this worse is that you have websites such as the Georgia Gazette, and they're profiteering off of people suffering. They take mugshots and publish them online, knowing that these images will ruin people's chances of moving forward in life. And for what? Clicks, ad revenue, and in some cases even charging people just to remove their images. This is not justice, this is exploitation. HB 10 needs to pass because no one should have to pay to reclaim their reputation. A person should not be branded for life before they've even had the chance to defend themselves. I hope my story carries weight today, not just for me, but for all of those who don't have the chance to speak. So I urge you to support HB 10 so that others like me and their families who rely on them are not unfairly punished before they are ever found guilty of a crime. Thank you.
Thank you. No questions from the committee. Appreciate you taking the time. All right. Next, I have Representative Scott.
Look, good evening, and thank you, Mr. Chairman. I rise today in strong support of HB 882, legislation that stands for fairness, dignity, and justice. This bill ensures that individuals who are merely accused of a crime are not forever hunted by a book and photograph that can tarnish their reputation, limit their opportunities, and negatively impact their future. The foundation of our legal system is innocent until proven guilty. Yet in today's digital world, a single mugshot, regardless of whether the person is acquitted or the charges are dropped, can remain online indefinitely, damaging careers, relationships, and livelihoods. HB 882 addresses this injustice by prohibiting Oh, I'm sorry, 10. HB 10 addresses this injustice by prohibiting the release of booking photographs until conviction is secured. This means that innocent individuals no longer have to fight to remove an image that should never have to find them in the first place. This bill also holds accountable those who exploit these images for financial gain. Too often, individuals are forced to pay costly removal fees to unscrupulous websites that profit off of their hardship. HB 10 provides a clear pathway for photo removal and established penalties for those who refuse to comply, ensuring that no one has to buy back their dignity. Justice should not be determined by an internet search. It should be determined by the facts, due process, and the rule of law. HB 10 upholds these principles, protecting the rights of the accused while still ensuring transparency and accountability in our legal system. I urge my colleagues to stand on the side of fairness and second chances. Let's pass HB 10 and ensure that no one is unjustly defined by a moment in time. Thank you.
Thank you.
I yield the podium.
Thank you, Representative Scott. It's always a pleasure to have you with us in committee. Let's see. Mr. Chris Bruce with the ACLU of Georgia.
That's me.
Good to see you again, Mr. Bruce.
Good to see you, Chairman. Good to see you, committee members. I'm not going to go through my whole speech, especially after what I just heard from Carl. So, Chris Bruce, Policy and Advocacy Director of the ACLU of Georgia, an organization dedicated to protecting Georgian civil rights and liberties, especially when it comes to the First Amendment and public access. So I'm up here to say the ACLU of Georgia is monitoring House Bill 10. Representative Schofield has brought a great bill, and we are doing a balancing act right now, especially dealing with free speech, the right of public information, but also people like Carl, who just came up here. I cannot tell you how hard it was for me to hear him speak on this bill and the way that mugshots have impacted him. And all I could think was how many other Carls out there who are not in this hearing, thank you, Representative Hawley, who have gone through the same thing. Someone who is an American citizen, skilled, can contribute, but is now draining funds because of a picture. Carl did not ask for his name to not be identified. He did not ask for the crime that he is accused of to be taken off. He just said it is a picture that is impacting his life. And for that, again, a balancing act that goes towards it. Thank you again for bringing up House Bill 10. Thank you for bringing this together. I also want to point out a few other things. ACLU, we have to go with constitutionality with things. This is not outside of the scope. Texas and the other southern states have passed similar bills like this. So this isn't something that Georgia's actually behind other states because they've seen what these pay for mugshot type of websites are about. And again, I'm going to leave on, since it is the late, Carl and plenty of other people are innocent until proven guilty. There's no reason why we should damn them with a mugshot. Thank you.
Thank you very much. Appreciate that. Any closing from the bill author?
I just thank you very much for your time, consideration. I thank the calls, and I just ask for favorable consideration for passage of HB 10.
Thank you. Anything from PAC? I didn't say y'all signed up. Okay. All right. Anybody else that I may miss? All right. What say the committee?
Second.
All right. May do pass second. Any amendments? Seeing none. Oh, excuse me. Yes, there is an amendment. All right. Who would like to make that amendment?
I'll make it.
All right. Representative Neal, go ahead.
I move to replace in its entirety LC 481353 with LC 481250S.
Everybody understand the amendment? I believe that bill passed out of this committee last year. I got moving second on the Neal amendment. All those in favor say aye.
Aye.
All those opposed, same sign. Any other amendments? Seeing none. Motion and a second do pass with the Neal amendment. All those in favor say aye. Aye. All those opposed, same sign. Congratulations, you're on the full. We'll see if we can get you on for Monday.
Thank you. Thank you very much.
Thank you. All right, Representative Ridley, take us on out of here.
All right. Thank you, Mr. Chairman. Hopefully this bill isn't the most complicated one of the day. House Bill 35, LC 481354. We passed it out of the Hong Subcommittee last year. Just didn't make it over for crossover. Even though it's 3 pages, it's pretty simple. Worked with PAC on the bill, just like last time. Increasing the pay for special prosecutors up to $250 an hour, and then allowing up to $110 an hour for staff. PAC supports it. They're here to talk about it, so I'll let them talk from here.
You have the floor, Mr. Smith.
Okay. Really quickly, when a elected DA or elected solicitor has an ethical conflict, means like they're having to prosecute a family member, prosecute a former client, things like that. Usually our mode is what we do is we appoint a conflict prosecutor from another circuit or another county. If we can't find anybody to do the conflict because they're too busy or they're unable to do it, we then can move on. We can appoint the Attorney General if they're willing to take it, or use some of our own staff attorneys to do it. If we can't get that group to do it, the final group is to use, per law, is to use a private attorney. The private attorney's salary or the hourly rate is capped at $66 an hour. There's no funds for additional staff. There's no funds for resources. So basically, and the Attorney General ran into this problem before they gave up having to do conflict prosecution. They were making appointments to private attorneys and only able to pay those people $66 an hour. They had no staff. They were handling murder cases down in Brunswick. All we're asking to do is to please let us be able to raise money to raise their hourly rate to $250 an hour and start. And this is not something we're going to be doing on a regular basis. This is if we can't get another DA or another solicitor to take it, or we can't get the Attorney General to take it, or there's no other resources. It ends up being this final level of who can take a conflict. And I'll give you a good example of what's going on right now. In the most recent election, the gentleman who is the new Solicitor General of Muskogee County is a very prominent criminal defense attorney. He can't prosecute his former clients under our ethical rules. The gentleman who was elected the district attorney for the Ogeechee Circuit, which is Statesboro, he too has a very thriving defense practice. And he just simply sends us a list saying, hey, these are my former clients. We have an ethical conflict because I can't prosecute a former client, and we go looking for people. We've done a very good job, and usually we can get folks to help us. But sometimes when you get hundreds and hundreds of cases, asking a DA or solicitor, you keep going further and further away from the county, and at some point you're taking a DA away from his or her own circuit and saying, hey, I need you to go spend hours handling a case in a different location. And some places just don't have the resources to do that.
I have one question, Chairman Gullett.
Yeah, I like the bill. I think it's important. I do want to know how often this is done, because ultimately you guys are coming and asking for more money because this rate's going up. So how often does it get to the very last piece of hiring a private person or a private attorney to make these prosecutions?
Rarely, if ever. And Chairman, we don't have a request in our current budget because the rate hasn't been increased. So if the rate is increased, we'll be able to do a better job of giving information to you and your committee as to how much this might be. But this is like the last stop. I mean, this is the one that's behind the glass that you break in case of emergencies. Rarely do we have to do that. Rarely do we get to this point.
Okay, thanks.
See no other questions. Sometimes it's good to go last. Any discussion from, I didn't see anybody else signed up. All right. Any discussion from members of the committee? What say the committee? All right, I got a motion to pass. Second. All those in favor? All those opposed, same sign. Congratulations, you're on the full. We'll see if we can get you on Monday. Thank you, sir.
Thank you.
We are adjourned.